welcome to Crime in Court. This is an episode of the Delphi homicides. We are talking about Indiana versus Richard Allen, and he is incarcerated. He received it back in December of this year. He received 130 years for the homicides of Abby Williams and Liberty German. However, he's like 90, I'm 99.99999% sure that he's been railroaded and innocent. So this episode is titled Motion to Strike States Misrepresentations. So if you recall, we have gone over, it's been a little while because I got the flu, I got ill, and then like Karen Reed is just taking up all my time. So I apologize for kind of letting this slip, but now we can kind of catch up and break these down by topic, which is kind of always a good thing when we break down these different filings by topic. I think it's kind of interesting to read them side by side. So we're going to read a couple different, well, one motion in particular and one announcement. So Richard Allen, now he's been moved, so he's no longer in Westville Correctional Facility. I can't remember the name of it. I think it's like Pendleton or something. I could be totally wrong. But he has been moved to a better facility, hopefully. And what was I gonna say? No, I forgot. Anywho, so he's been moved and he has now a new appellate attorney. This is a filing from that appellate attorney. It says acceptance of appointment and formal notice of appointment of outside counsel. Amy Carrazos is a public defender of Indiana and acknowledges receipt of certification that the above captioned court has been unable to provide local counsel to represent the indigent defendant in the above captioned cause for the purpose of perfecting a direct appeal. So this is all for his appeal. She accepts the appointment to represent Richard Allen. I hereby appoint Stacy Juliana um, and attorneys. Wait, so Stacy and Mark Lehman. Attorneys competent. So sorry. Here, let me highlight where I'm reading that. So without reading all their gobbledygook. So Stacy and Mark, attorneys competent in the in the practice of criminal law, subject to the concurring appointment of record by the Honorable Francis C. Gall. So at some point, Richard Allen, like right after he was sentenced, his attorneys were like kicked off of his docket for some reason, and he was no longer represented by anybody again, which I think was dirty tricks by the state to try to get him like to try to do something to him in Westville. I don't know, but that's where he went. So interesting that, huh? But anyways, so pursuant the minimum fee for services and any attorneys appointed by the state public defender and judge under a request made to the state public defender may not be less than the state public defender whatever that means. I have no idea. But anyways, these two are now going to be assigned to his case. This particular Amy Carrazos, and then she's appointing Juliana and Lehman to his case. So he will no longer have Andrew Baldwin or Bradley Rosie. However, because of that little mix up where there was no lawyer on Richard Allen's docket for a short time, Andy Baldwin had to put in he had to make a filing with the court to say that he wanted to be back on the docket and temporarily until they had some of these filings figured out, because they're not ready to appeal until they get through some of these filings, which is the motion to correct error and the motion to strike the state's response to motion to correct error. I don't think we went over this because at this point in time, I think I had the flu. So I think this is new to you, or it's new to me. So I apologize if it is not new to you, but we are going to go through these and break them down as best we can. So here is the defendant's verified motion to strike the state's response to motion to correct error. So they the defense filed their motion to correct error. The state responded, and there were things in their response that the defense was like, you know what, that's incorrect. So let's try to get that stricken from the record. The defendant, Richard Allen, by counsel, now comes before the court with his verified motion to strike the state's response to motion to correct error, filed on February 4th. For the reasons that follow, the court should strike the state's response in its entirety from the record of this case. The state's response is unverified and, without supporting affidavits, asserts numerous facts outside the records of violation of Trial Rule 59H2, which provides if a party opposes a motion to correct error made under this subdivision, that party has 15 days after service of the moving party's affiance and motion in which to file opposing affidavits. So obviously, they have 15 days to file then. That's what that means. All right, so a motion to correct error under trial rule, unsupported by affidavits, presents nothing for a court to consider. So, because Nicholas McClelland filed his response with no affidavits to support any of the things that he stated, the court should not even consider his response, is basically what that means. In particular, on page 2 of the state's response, Mr. McClelland alleges on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant herein attached as state's Exhibit 3, which unfortunately we don't have. That was part of their exhibit, but all the or part of their filings, but the exhibits were sealed. So that allegation is based on facts outside the record and unsupported by an affidavit or verification in violation of Trial Rule 59H2. On pages 7 through 9 of the state's response, Mr. McClelland alleges the defense received the van video and any information pertaining to Ron Logan, including in Mr. Allen's motion to correct error on January 30th, 2024. That allegation, Mr. McClelland asserts, is supported by State's Exhibit 7, a discovery release. These allegations are based on facts outside the record and unsupported by an affidavit or verification in violation of the Trial Rule 59. On page 8 of the state's response, Mr. McClelland says Reese, I believe it's pronounced Reese Davis, was interviewed by law enforcement, which he was, as shown by the defendant's exhibits 4A, 4B, and 4C. But Mr. McClelland also says Mr. David requested a polygraph examination, which he failed miserably. No exhibit of Mr. Allen's says anything about a polygraph examination. These allegations by Mr. McClelland are based on facts outside the record and unsupported by an affidavit or verification in violation of Trial Rule 59. Similarly, on page 8 of the state's response, Mr. McClelland says that Ron Logan told Mr. Davis he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned them. Okay, so that is Mr. McClelland says that Ron told that to Mr. Davis. Nothing in any of Mr. Allen's exhibits pertaining to Ron Logan's confessions to Mr. Davis say anything about Logan removing a battery out of any phone. Similarly, nothing in Mr. Allen's exhibits pertaining to Ron Logan's confessions to Reese Davis say anything about Logan burning the girl's clothes. These allegations by Mr. McLeland are based on facts outside the record and unsupported by an affidavit or verification in violation of Trial Rule 59. And we have a footnote here. It says the tip in the Orion database, Defendant's Exhibit 4A, does recite Logan told Reese how he burned his clothes in a fire pit and where it was located. Burned his clothes in burn pile. But again, nothing anywhere says anything about Logan confessing to taking a battery out of a phone. While the court might take Mr. McLeland's misstatement of fact about the burning of the clothes as simply a mix up on his part, either McLeland is making up the allegation about Logan removing the battery from a phone out of whole cloth, so he's just making it up out of nowhere, or he has access to information about Ron Logan's confessions to Reese Davis that he has not shared with the defense. Mic drop. But it goes on. In either event, there is a reason that Trial Rule 59 requires affidavits in support of a response to a motion to correct error when that response is based on evidence outside the record. So, as you can see, there are things that Mr. McLeland stated in his response, his opposition to the motion to correct errors, that were never in any any evidence that was received by the defense. So this is all news to the defense team that Ron Logan stated that he burnt the clothes and he removed a battery. That was the first time we're hearing about this. So that is they need to investigate why we've never heard that before. Also, on page 8 of the state's response, Mr. McLeland says no evidence places Ron Logan at the scene of the homicides. This allegation by Mr. McLeland is based on facts outside of the record and unsupported by an affidavit or verification. On page 9 of the state's response, Mr. McLeland says Sergeant Cecil was able to observe photos of the phone when it was found, herein attached as State's Exhibits 9, 10, and 11. Got a footnote here, which says the court might want to consider whether to hold Mr. McLeland in direct criminal contempt for publicly filing crime scene photographs that the court ordered sealed at Mr. McLeland's own request. Uh-oh. Nick McLeland keeps stepping in it. So Nick was like, hold on, Judge, we can't have any kind of leaks and we need to have, precautions made. And, he made this big deal about the defense team needed misconduct or ethical issues filed against them. And we had to have like a whole hearing about it and take away from the preparation of the trial, because there was a photo supposedly leaked by the defense, which I still find very suspicious when I think that there were leaks happening on the state side long before that ever happened. I kind of think that the state may have had something to do with getting that guy to leak it, possibly. I'm not sure, and that's totally speculation on my end, but it just seems so suspicious to me that the state was leaking things, but also someone just happened to be a confidant of Andrew Baldwin and break that confidence within him and steal photos of a crime scene and leak them. It just something about it just doesn't make sense to me. But anyways, so all that being said, The defense got into so much trouble. The judge kicked them off of the case because of these so-called leaks. And now here we have Mr. McLeland leaking, publicly filing these photographs that were sealed of Libby's phone. They were sealed though. Like all the crime scene photographs and all that sealed. Anything that was taken at the crime scene sealed. So the public can't see it. But yet Nick McLeland, Mr. Everything's got to be sealed, just releases it for the public. So interesting that he does that. And the defense has a little sass and says, you might want to consider maybe holding them in criminal contempt, like you tried to hold us, because, yeah, they didn't listen to your orders, Judge. Where, as here, the court has firsthand and immediate knowledge of acts demonstrating a clear disregard for its authority, which threaten to undermine the integrity of the judicial process, summary proceedings for direct criminal contempt are available. So, because of Nick McClelland's complete disregard for Judge Gull's authority, Judge Gull has the right to continue with some criminal contempt proceedings on Nick. The power of Indiana courts to summarily punish for direct criminal contempt while specified by statute rests upon the common law. It is inherent in the courts. Alternatively, under Indiana Code 344731 and 344735, the court might consider issuing a rule to show cause why Mr. McClelland should not be held in direct criminal contempt for his willful violation. So you might want to do so, Judge. You might want to hold him in criminal contempt. And if you don't, you should tell us why you're not holding him in criminal contempt. We need an answer. Of course, she's not going to, but I love the sass from the defense attorneys. All right, so in addition to not saying whether Sergeant Cecil actually observed those photographs, this allegation by Mr. McClelland is based on facts outside the record and unsupported by an affidavit or verification. Also on page 9 of the state's response, Mr. McClelland agrees that Sergeant Cecil's testimony that the log entry on Liberty German's phone reflecting the headphone behavior, so that device, the auxiliary device, so we don't have it on like the more updated phones, but back then it used to be, I think, up here where you would plug in your phone, your earphones, your earbuds or whatever, and then that was your auxiliary cord, which you could also use an auxiliary cord plugging it into like your car outlet and then play your music and stuff on there. But it would also charge your phone. So those are some ways in which you could use that auxiliary charger. And if you recall, someone plugged it in and around five something. I can't remember the exact times. I'm sure they'll tell us around five something, and then it was unplugged around 10. Um, and long after the timeline of when the girls are supposedly already, their lives had already been taken at that point. Because the timeline, what is like 2:30, 2 to 2:30, and then things are happening on their phone after 5. So just odd stuff. So McClelland alleges that Sergeant Cecil's testimony that the log entry on Libby's phone reflecting the headphone behavior could have been caused by a malfunction due to dirt or water in the headphone jack and was based on his knowledge and experience as a forensic phone examiner. This is not true. Sergeant Cecil's trial testimony about the possible effect of dirt or water in the headphone jack was based entirely on a Google search performed during the break in Mr. Allen's trial. The allegation that Sergeant Cecil's opinion then had anything to do with his knowledge or experience is based on facts outside the record and unsupported by an affidavit or verification in violation of Trial Rule 59. On page 10 of the state's response in subparagraph 4, Mr. McClellan says there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage because that kind of damage is not registered in the logs, reports, or extractions of that phone. Whether or not there was water damage can only be determined by physically examining the phone. So, did he just open it up for, hey, you just invited the defense to physically examine the phone? I would say so. Maybe they have to. Mr. McClelland is not an expert and attempts here to testify as if he were one, and lawyers are not supposed to testify. This pleading is not his first attempt. The sass. The sass coming from, I want to say this is Baldwin. Hold on, let's see. Yeah, I believe Andy Baldwin wrote this, and I am loving his sass. This is great. Like, this is the most sass I've seen from him in one pleading. It's great. All right, so every single allegation of this subparagraph quoted above is based on facts outside the record and unsupported by an affidavit or verification. All the allegations above, based on facts outside the record and unsupported by affidavits or verification, are crucial to the state's response. Because the absence of supporting affidavits or verification by Mr. McClellan violates Trial Rule 59, the state's response should be stricken in its entirety from the record of this case. In addition to alleging facts outside the record of the case without supporting affidavits or verification of the facts in his own motion, which you're not supposed to do. Like I said, the attorney's not supposed to testify. If you have something that you want to contest that, another expert is saying, you have to get an affidavit from an expert, or you have to have some kind of even your own affidavit stating that you've done your due diligence and research and whatnot, but none of that was provided. In addition to alleging facts outside the record of the case without supporting affidavits or verification of the facts in his own motion, Mr. McClellan repeatedly misstates the law and therefore misleads the court. On page 2 of the state's response, Mr. McClellan says the statute governing safekeeping orders, Indiana Code 3533.11.1, does not require the court to have a hearing to make this determination. The court can make the determination based on the motion alone. He repeats this assertion on page 3, saying that Judge Diener was within the jurisdiction of the statute to make a ruling on the safekeeping motion without a hearing. This was moving him into solitary confinement without his knowledge, without his consent. You can't just move him without his consent. And he could have said, "No, I don't want it." He was not given that opportunity. He had to have been given the opportunity to decline because it was only for supposedly for his own safekeeping. That's what the state was saying. So he had the option to decline it. And he had the option to have an attorney present at a hearing, which didn't happen because they, I think, purposely didn't tell the attorney and were trying to hide him in the system because they changed his name and they put the whole thing when he first got into prison, they moved him around a couple times, changed his name, all while he didn't have an attorney. So tell me what was going on there. But this cannot be so as set out in Mr. Allen's verified motion to correct error on page 6 under the next section, Indiana Code. Mr. Allen had an absolute right to refuse the transfer. He had the right to refuse transfer to the Department of Correction, which is he's going to prison where other convicted felons are going, whereas he was in the custody at the time of the county jail, which is where he should have been because he was awaiting trial and not a convicted felon at the time. So he had a right to refuse transfer to the Department of Correction because then Sheriff Lesenby had only alleged the safekeeping request was to protect Mr. Allen's personal safety. So, how could Mr. Allen have exercised that statutory right if the court could make factual findings based on then Sheriff Lesenby's motion alone? We have a footnote here. Oh, it's a long one. Oh, nope, that one's short. Okay. The state's response does not explain how there was any evidence before Judge Diener from which he could make a factual finding without a hearing. So, nothing in Nick McClellan's response says why the judge could do so. There's no case law stated, there's no examples, just that, yeah, he can do it if he wants to. And I'm just going to repeat myself over and over again, and it's going to make it a true statement. That's what liars do. But anyways, so yeah, he's trying to make, uh, there is no evidence before Judge Diener, which he can make a factual finding without a hearing to support his safekeeping order because then Sheriff Lesenby's motion was unverified. Unverified. So he could not have, of course, and Mr. McClelland's interpretation, for the lack of a better word, of the statute is completely unsupportable. Got another footnote here. This is the long one. At pages 2 and 3 of the state's response, without denying that he knew Mr. Allen was represented by Brett Gibson, Mr. McClelland attempts to make much of Mr. Gibson not having filed an appearance for Mr. Allen. So Mr. Gibson was the attorney that was originally hired by Kathy Allen days before the safekeeping order. So and they knew because they responded, the sheriff did anyways, that said, "Yep, okay, we understand you're counsel now for Richard Allen." Got it. But yet then they did all this stuff behind Mr. Gibson's back and Mr. Allen's back to move him. Very, very interesting stuff here. So Mr. McClelland attempts to make much of Mr. Gibson not having filed an appearance for Mr. Allen. On page 3, for example, the state's response says, as of the filing of the motion for safekeeping, the defendant did not have an attorney of record, which is just a big old fat lie, because he did. And we saw the proof of it. We saw the receipts of when Kathy Allen paid the man. She gave the man a retainer, therefore hired. And it was days on the calendar prior to when they tried to move him. This complaint should strike the court as odd because Mr. McClelland appeared at Mr. Allen's initial hearing on October 28th and filed the state's verified request to prohibit public access to the court record the same day with no service of that motion on anyone, of course, even though he knew that Mr. Allen was represented by Mr. Gibson. So, like I said, they were not notifying his attorney of things going on in his case. You can't do that. And on November 22nd, 2022, Mr. McClelland both filed his request for what became known as the gag order and appeared for the state at the hearing on his request to prohibit public access to a court record. But Mr. McClelland did not file his own appearance in this case until the next day, November 23rd, almost a month after he initiated the case. It is apparently, that's odd, It's apparently enough that everyone knew for a month that Mr. McLeland represented the state without his having an actual appearance on file. That's odd. Everyone just knew he was going to be representing the state in this case against Richard Allen, but he hadn't filed it formally with the courts. But it is insufficient for Mr. McLeland and then Sheriff Lesenby, at the very least, to have known Mr. Allen was represented by Mr. Gibson, regardless of Mr. Gibson's not having filed an appearance. A somewhat worn saying about glass houses should come to mind. He actually, I believe, emailed both the am I missing a page? No, it just goes right into another sentence. We're missing something, but we're not because we're on page 6 and previous page is 5. So, oh, because we're on a footnote. Duh. Okay. I can only do so much at once. My brain can't handle it. All right, so on page 4 or on page 5 to 6 of the state's response, Mr. McClelland says the presumption of prejudice from the United States versus chronic is only applied in cases of non-representation throughout the entire case. Apparently, Mr. McClelland is unacquainted with footnote 25 of Chronic, which unambiguously says the court has uniformly found constitutional error without any showing of prejudice when counsel was either totally absent or prevented from assisting the accused during the critical stage of the proceeding. And Smith and Brown, the Seventh Circuit case, McClelland replies only saying nothing different in Chronic. In Chronic, the court explained that presuming prejudice would be appropriate in the face of a complete denial of counsel or denial of a critical stage of the litigation. It really is not debatable that Mr. McClelland has, at best, misunderstood Chronic. Our recent cases make clear that, contrary to the Court of Appeals' conclusion below, denial of counsel at any critical stage of the criminal prosecution is per se constitutional error. On page 6 of the state's response, Mr. McClelland calls the van video, defendant's Exhibit 3A, at best impeachable evidence. That is not so. Agent Pohl's testimony about a prior inconsistent statement by Brad Weber would have been merely impeaching. The video van is substantive evidence of when Brad Weber arrived home in his van. So that's the big difference. Impeachment evidence is basically just to make your witness on a stand seem less credible, whereas this is actually substantive evidence that would place him at a certain place at a certain time, which is critical to this case. It's critical to the timeline of the homicides. So, under the silent witness theory, video recordings and photographic evidence may be admitted as substantive evidence. More importantly, on page 6 of the state's response, oh wait, I missed a footnote here. Hold on. Also on page 6, Mr. McClelland says Defendant's Exhibit 3A, the van video, is in the form of a YouTube link that is not identified as an item of evidence by the Indiana State Police number and therefore is an improper submission for consideration by the court. Really? You're going to nitpick like that? In fact, as Mr. McClelland must know, Mr. Allen properly filed the video file that is Defendant's Exhibit 3A with the court on a thumb drive. Of course they did. Mr. Allen also properly served the state with the exhibit in the same way. The web link was provided in Mr. Allen's motion to correct errors simply for ease of viewing by the parties and the court. So he's like, you freaking idiot. We gave it to you in a thumb drive so you can access it, the actual raw video, but we gave the YouTube link here because it's a filing and it's easier to do that way because we live in an electronic world now. But okay. And Mr. Allen is unaware of any requirement that his exhibits be identified by an Indiana State Police number, especially when the video recording was provided to the defense, again, as Mr. McClellan must know without such a number. So you're going to sit there and be like, well, it's not actually, it doesn't have the right proper number and uh, it's not filed correctly, it's not labeled correctly, so you can't use it. But that's the way we got it from you. So how are we supposed to not use it? Because that's the evidence you gave us. So ridiculous. Their arguments are so dumb. Like we're just in bizarro world. It really is. All right, so more importantly, on page 6 of the state's response, Mr. McClelland erroneously asserts that a motion to correct error only applies to newly discovered evidence. Actually, Trial Rule 59, by its own terms, provides for motions to correct error based upon evidence outside the record. So these are things that were found outside the record of the court, and it's allowed to bring in some other things if you have other things to bring into the record to correct the record. So the rule says nothing about newly discovered evidence. Defendant Exhibit 3A, the van video, is evidence outside the record. And Mr. McClelland has no answer to Mr. Allen's claim under Nap, Napu versus Illinois. I have no idea how to say that. That from from the van video in his possession, Mr. McClelland knew or should have known that Brad Weber's testimony critical to the state's case as presented to the jury, that he arrived home in his van about 2:30 p.m. on February 13th, 2017, and that's before Libby's cell phone stopped moving at 2:32, which makes the timeline not fit. And that was false because they didn't elicit they didn't have the correct time. And two, Mr. McClelland did nothing to correct Mr. Weber's testimony. That's from that case, Napu. A conviction must fall when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. So even if the state didn't mean to do it, even if it wasn't soliciting false information, and let's just pretend Nick didn't know he was eliciting false information, it still needs to be corrected because it can't go uncorrected on the record. So, um, I'm just gonna tell you, you know what Judge Skull's gonna do. So, this is more for appellate reasons, which they need to get on. They need to get all of this on record before they can appeal. Is my conclusion that they're trying to get all of this down on paper and getting Gull and Nick McClelland to double down on their lies and their BS so that they can put more and more in their appeal about it, is what I think. All right, so it is irrelevant whether the defense knew about the false testimony and failed to object or cross examine the witness because defendants cannot waive the freestanding ethical and constitutional obligation of the prosecutor as a representative of the government to protect the integrity of the court and the criminal justice system. Everything above about Defendant's Exhibit 3A, the van video, applies equally to Defendant's Exhibit 3E and the FBI subject information sheet for Brad Weber, which shows Mr. Weber's cell phone first began pinging at his family's house at 2:50 p.m. So, where was he from 2:30 and to 2:50? If it didn't ping, he was driving past, going towards his house. seen right by his house at 2:30, but he doesn't ping inside of his house until 2:50? That's what was he doing something outside for 20 minutes? I don't know. All right, so on page 7 of the state's response, Mr. McLeland says the subject information sheet for Mr. Weber is not newly discovered evidence and at best impeachable evidence. Defendant Exhibit 3E is substantive evidence of when Mr. Weber returned home in his van, and because it was in the state's possession, Mr. McLeland either knew or should have known Mr. Weber's testimony that he returned home about 2:30 p.m. And that was false. And as with the van video, Mr. McLeland did nothing to correct Mr. Weber's false testimony. Mr. McClellan seems to be under the impression that all his evidence is substantive, while contradictory evidence presented by the defense is merely impeachable. This is a piece with his idea that actual cell phone data showing headphones were plugged into and unplugged from LG's cell phone hours after 2:32 p.m. indicates that data was caused by the dirt or water damage, all because that data would otherwise disprove the entire case that he presented. So basically saying like, well, of course, Nick McLeland is going to say that it's just dirt or water damage because if it was anything else, it's going to damage his case. It's his case is destroyed if those girls that timeline doesn't match and things were happening and yeah. So 2:32 is supposedly when the phone stopped moving, but yet other activity is happening with the phone and that makes no sense. And everyone is to assume that case must accurately be portrayed must have accurately portrayed what happened. Finally, the one affidavit Mr. McLeland does have supporting the state's response is State's Exhibit 5, executed by Tobe Lesenby. The problem with that is Lesenby's affidavit directly contradicts, at least twice, his sworn testimony at the safekeeping hearing held on June 15th. So if you remember, there were multiple hearings way back when. We've gone through all that. We've gone through the testimony, the transcripts of the safekeeping hearing. There was also a like 3-day hearing with a bunch of other things, the contempt stuff. Like we've gone through all of those transcripts somewhere on my channel, so they are here. So first, in his affidavit, Lesenby says that Mr. Allen was transferred to the White County Jail on October 28th. Because of overcrowding at the Carroll County Jail. At the safekeeping hearing in June 2023, Lesenby explained Mr. Allen's transfer to the White County Jail as follows. So this was what I was talking about, how he was being transferred from jail to prison then. And so this is the transcript. Question. And so tell the court what arrangements you made to have him placed in White County. Answer. Just a matter of simply having direct communication with Sheriff Bill Brooks and explaining my concerns of potential safety and security of our facility and ask him if he could temporarily hold Mr. Allen for us. Question. Okay, and were you confident that Mr. Brooks and his facility was adequate to hold him on a temporary basis? Answer. At that time, yes. There is not a word about overcrowding at the Carroll County Jail being the reason for Mr. Allen's transfer to the White County Jail. In his affidavit, Lesenby, so he must have testified to that then, that it was overcrowded. In his affidavit, Lesenby also says that Judge Diener at no time gave me legal advice on the motion pertaining to safekeeping. In the first instance, Lesenby is not competent to say whether Judge Diener gave him legal advice. In the second, Lesenby unambiguously said that Judge Diener adjusted the language in Lesenby's safekeeping order. Yes, he said that um, Judge Diener basically wrote his safekeeping order, or helped him write his safekeeping order. Question. All right, and is that the motion that I've just alluded to that was filed by you, signed by you, and filed back in November of 2022? Answer. Yes, sir. Question. Did you draft this motion yourself? Answer. Actually, I had presented a similar motion to request, I should say, to the court and as I recall, the court had actually come up or provided this particular document. If you recall, by the way, Judge Diener was the judge just before Judge Gull, and he recused himself out of nowhere. So we don't know why he recused himself, but I think it's because of this. So he says he actually came up with and provided the particular document. Question. Okay, so let me see if I can ask one more direct question. Did you prepare this motion in your office on a computer, essentially? Answer. I prepared a similar motion to this. Again, the wording was adjusted by the court, meaning Judge Diener wrote it for him or rewrote it for him. Judge Diener also asked Lesenby to sign the safekeeping motion, which Lesenby did. Leaving aside the improper ex parte communications, you're not supposed to be talking to a judge all by yourself there, buddy, between Judge Diener and Lesenby, adjusting the wording of a motion to be filed in his court. So he basically had a hand in a motion that was going to be filed in his own docket, and he had the power to approve or deny. So it's like he has the power, and he's saying this is how you should word it so that I can approve it, basically, which is highly unethical. So obviously constituted both reviewing and drafting a document with Indiana Judicial Conduct Rule 3.10 prohibits, except when done for family members. So judges are not allowed to be doing that. And reviewing and adjusting the wording of a motion is most fundamentally the giving of legal advice, which Rule 3.10 also prohibits. So from this judicial conduct rule prohibits them from being able to adjust the wording of a motion. So Judge Diener might be in some hot water for this one. Just saying. Respondent admits I believe he just retired, actually, but that's not going to stop it from what's coming. So Respondent admits that the Commission's allegation that his letter advised the couple on the legality and effectiveness of the documents he had reviewed. This constitutes the practice of law by giving legal advice. Mr. McLeland solicited then from Lesenby an affidavit saying Judge Diener had not given Lesenby legal advice when McLeland knew or should have known that was simply not true. So there's another lie that he tried to elicit from one of the witnesses on the stand, and it was not true. It is not all that different from letting Brad Weber's false testimony go uncorrected. So Brad Weber also had false testimony regarding his timeline and when he came home and whatnot. So that was another thing that they had wanted corrected. In sum, in violation of Rule 59H2, the crucial facts on which the state's response depends are outside the record and are unsupported by affidavit or even verification of the response itself by Mr. McLeland. The state's response also pervasively misstates the law and therefore misleads the court. Finally, the one affidavit the state did submit in support of its response alleges facts that Mr. McLeland knew or should have known are not true. For all these reasons, the court should order the state's response stricken from the record because the state effing lied. Conclusion. For the foregoing reasons, Mr. Allen respectfully requests that the court strike the state's response for the record, of this case and either vacate Mr. Allen's convictions or set his motion to correct error for a hearing. Mr. Allen also requests any other appropriate relief. What do you guys think Judge Gull is going to do? Well, we don't have to wait for it because she ruled almost immediately. Whoops, that was not on page 1. Here we've got, so there were multiple motions, remember? So one of the motions that was within the motion to correct, or within that bunch of motions together and filings and things, there was a motion to correct abstract of judgment, which talked about how, I think it was in Judge Gull's sentencing, where she put on the record that Richard Allen didn't have mental health conditions or mental health concerns, which is not true. We know that he did because they occurred while he was incarcerated. We also know that in one of his interrogations, or the interview that turned into an interrogation, which I think it was always meant to be an interrogation, he specifically told Holman about his mental health conditions. And I think personally, and I'm speculating here, but I think that they used that against him, knowing that he could be easily persuaded to make a false confession. They used that for the purposes, I mean, they put him in solitary for the purposes of eliciting a confession out of him, or 61 or however many confessions there are. So, in her judgment, she said that he had no health conditions, mental health conditions, but they wanted that corrected because he, in fact, it does and has a record of it before ever being arrested. But of course, she denies this without a hearing because that's how Judge Gull rolls. She's just gangsta like that. All right, so the court, having received defendant's Richard Allen's verified motion to correct errors, so the motion to correct errors that we're talking about here, so the whole, they filed theirs, then the state filed their response. Now she's saying, I read the defendant's motion, I read the state's response to correct error, and the defendant's verified motion to strike, which is what we just read now, to strike the state's response to the motion to correct error, which was filed February 14th. And look at what date this is filed, also February 14th. So the same day that they filed their motion to strike, the same day they filed it, Judge Gull denies it with all these others. So she was just in a denying kind of mood, I guess. So she further denies the defendant's verified motion to strike the state's response to motion to correct error without a hearing. She denies everything without a hearing, and there you have it. So there are still more motions that we have to get through, and a few more episodes that I have planned. So we will get into the motion to preserve evidence. There is specific evidence that was not turned over to the defense and they want it. And we'll talk about that. We'll talk about Judge Gull still hiding things in Carroll County because there have been multiple media requests, public requests, FOIA requests for the public trial exhibits. It's ridiculous, the answers that the clerks are giving back to the public, saying how they can't provide that information because blah, 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 blah. So we're going to do a whole episode on that too. So I got to get that prepared for you guys. But Judge Gall is hiding everything from the public, as we know. We're not new to learning that. So we'll do an episode on that, and we'll do some more interesting stuff on the Reese Davis letters and what those might entail. So Make sure you are subscribed. Please hit that like button for the algorithm as it really helps. And I will see you guys in the next one. Thank you so much for watching. Take care, guys. Bye now.